Hi, it's Phil Buzzelli. I'm a partner with Spielberg Bozelli in Princeton, New Jersey. Wanted to discuss short sales, what they are, procedurally what happens, why they occur. Short sale is when a seller must sell a property whose value does not exceed the amount owed on the existing mortgage. In this event, there's obviously not enough money to pay the lenders in full, so the seller must negotiate with the lenders to agree on a lesser amount owed, which will allow the seller to sell the home and allow the lender to get some compensation as much as possible. In a short sale situation, it's very unlikely the seller will get any money back from the transaction. However, they do avoid foreclosure. They are able to sell the home and benefit by means of not suffering through a foreclosure. Steps in proceeding with a short sale transaction. Procedurally, they work the same way. You're going to sign the standard realtor contract. You're going to have your attorney review the contract, provide any modifications, adjustments to that. The one difference with a short sale transaction is that there must be a specific contingency which calls for short sale approval. It's not uncommon not only to have one lender, but two lenders. Perhaps there's a line of credit on the property, something along those lines. In that event, a seller must obtain approval from both lenders in order for the short sale to be acceptable and in order for the transaction to be completed. A realtor's role in a short sale transaction is very important. A realtor, must contact the lenders directly. Typically, the realtor and not the attorney is the one that will upload everything to the lenders. There's secure portals which allow a realtor to send any documentation to the lender directly. An attorney will assist in providing these documents to the lender, but it is ultimately the realtor who uploads everything and will send it to the lender's portal, at which point the lender will confirm that the short sale is allowed and approved. Again, it's very important. You must obtain approval from any lender involved. Any liens, judgments, anything must be satisfied as part of the short sale. So an attorney's role in a short sale transaction is to compile any figures, any mortgages, any liens, any association dues, any taxes owed, any commission owed. All of those figures are calculated in seeing if the lender will approve the short sale transaction. Again, the lender is going to have a certain minimum within which they would only be willing to accept as part of the transaction. If you're able to get to a figure that the lender will approve and in which all other entities will be satisfied, as discussed, HOA, taxes, etc., they must all be satisfied as part of the closing. If you're able to get approval from the lender, you're then able to close on the transaction. The seller's bottom line at closing will typically be zero, as again, these entities who are owed money have agreed to accept less, in essence, to avoid the trouble of going through foreclosure and other issues with simply the seller defaulting on the loan. As far as a buyer is concerned, procedurally, the transaction works the same, with, again, the one exception. There is a short sale contingency that must be satisfied. So if lender approval cannot be obtained for the short sale, the seller can legally void the contract, and parties have no other obligations or rights against each other. So this contingency has to be satisfied. It's important for the buyer to be aware that this contingency exists. Also important for realtors to be aware that this is something that must be required. That goes to the due diligence of the realtor. When you're listing a property, you want to make sure that there's no outstanding liens or judgment, because if a short sale contingency is not placed in the contract, and if the seller is not willing to transfer title based on the excessive amounts owed on the property, the seller would be construed in breach. So it's important to know these factors up front. Procedurally for a buyer, it works the same way. You'll have a contract, you'll have attorney review, you'll be able to perform your inspections. Now, since there's typically no room for repairs to be performed, credits to be provided, etc., the buyer's inspection is usually for the buyer's sole purpose of determining whether he or she is willing to assume any defects with the property. This is mostly understood in these types of transactions. Usually you have investors, things of that nature, but It's still important for a buyer to perform an inspection. If an unknown condition exists in which the buyer is not willing to assume, the buyer has the ability to get out of the deal at that point. So that's an important factor. The title searches are performed on the buyer end. A survey should also be performed. The buyer typically will have to secure his own mortgage for the property, so it's important for that contingency to exist as well. And then the closing happens once and if seller obtains lender approval. Procedurally for a buyer, it works the same, again with the knowledge that this short sale contingency exists.